For some time now, myself and many others have claimed that the council tax is an unfair system. We once had rates, we then went to a poll tax, and then around 1992, I think it was, we had the council tax. And we've been living with this for a long time. However, there are some changes which we believe, the chap I've been working with and myself, has made the council tax untenable, fraudulent, and ought to be abolished. And we'll show you why. We've put together a small presentation in text form, which I hope that you'll be able to follow. So let's have a look. First of all, let's start with the old maxim that ignorance of the law is no excuse. So this is referring to council tax liability orders. And you can go online at Council Tax Administration Enforcement Regulations 1992, and there is a link. And on that link, we'll go there in a second, you'll see that from 1992 to 2003, courts issued the Council Tax Liability Order. The statute provided two templates in Schedule 2 of the Act, Form A and Form B. Let's just have a quick look. If we bring them up here on the legislation website, as you can see, we're on there. And we've got Schedule 2 here. Form A, Forms of Liability Order and Warrant of Commitment. And you can see how it's been laid out with the money suggested, sum payable and outstanding. And this is how they would be typically put together. And then there's Form B, which is very similar, but it's got a table. Now, there's a difference between the two forms, as we will find out. So, Form A is for an individual debtor. So, in other words, somebody on their own who hasn't paid the council tax. And Form B is for a number of debtors who are to be listed in a table, which is the table we looked at just now. And this would be attached to Form B. The template provides for the name of the magistrate's court and requires the signature of the Justice of the Peace. Now, please bear in mind that this is secondary legislation, and as such, it doesn't get amended. They only amend the primary legislation, so there have been amendments, so these forms now shouldn't really be there because they are no longer applicable. So why are they no longer applicable? Let's find out. You see, before 2003, this document was a court document, and the council would leave the court with a liability order signed by the Justice of the Peace. So that's with that liability order, they could come along and say, well, you haven't paid, I'm ever so sorry, but we've got a court order, it's signed by the Justice of the Peace, we can now come along and get that money from you using a court bailiff, in actual fact. Not so much an enforcement agent, but a court bailiff, because they've got something from the court, a piece of legal paper. However, and this is where things start to go a bit murky, because if we go back, we'll now see that things have changed. You see, the Courts Act of 2003 introduced reforms aimed at modernising court administration, which led to the restructuring of the court system in England and Wales. And as part of that restructuring, the government issued a directive. Now, what is a directive, you ask? Well, if we have a look on Google, just as a quick example, we see that a directive is an order or an instruction, especially one issued by an authority, such as a government, an instruction or guideline that indicates how to perform an action or reach a goal, an authoritative decision from an official body, which may or may not have a binding force. Cambridge Dictionary says a directive is an official instruction or order, such as a federal directive forbidding fundraising in government offices. The word can also mean an official order or instruction in business, such as the latest European directive on working hours. So it's a it is effectively an instruction or order. This directive, this government directive, was issued by the Ministry of Justice. So the question is, how important was the directive from the government? Well, this directive would have affected Form A and Form B. How do we know that? Well, a Freedom of Information question was asked, and we have the answer, and we'll come to the answer in a minute. The question was ever the information of the statute law made available to those relevant employees within the HMCTS, which is Her Majesty's, or His Majesty's now, His Majesty's Courts and Tribunal Services, including the legal advisors, that the notifications / spreadsheets issued by the Council were not liability orders and should not be marked up as liability orders and were not court documents. If so, when was this information available? This went to Sion E. Jones, who answered it, the head of Legal and Professional Services, and we have the answer here. And the answer is the deprescription of liability orders took place in 2003. Since that time, His Majesty's Courts and Tribunal Services and its precursor organisations have employed thousands of legal advisors, and we have no records of the date when each one became aware of the change. So what she's saying here is they do not know when, but more importantly, if it was implemented. And this was 20 years ago. She goes on to say legal advisors were reminded of this directive in March 2023, which is more or less a year ago. And as you can see here, this came from Sion E. Jones, LLB, Head of Legal and Professional Services, Legal Operations. So, the Court Act changes, these changes that this Court Act has been made, resulted in the Council Tax Liability Order after 2003 no longer being recognised as a court document. Now, I just want you to just bear that in mind, what that means. As it says, the Council Tax Liability Order after 2003 is now no longer being recognised as a court document, and instead it's just been transformed into a notice. And we know what notices are. A notice is like keep off the grass or no ball games, that sort of thing. It's a notice, that's all. It's no more. So, consequently, this notification ceased to bear the authority of the court. With the document status altered to that of a notification, there ceased to be a judicial function for the Justice of the Peace to sign what now had become simply a notification. Why would a judge sign a simple notice? You wouldn't need to. He wouldn't have to. There would be no need, and the chances are he wouldn't want to. It's just a notice. But they continue to sign this notification. And this notification was not generated by the court, but actually generated by the claimant, the council. Now, that's a bit strange, is it not? What's the council doing generating a notification that is pretending to be a liability order? So let's just follow this through then, shall we? The magistrates just pronounced the order for the defendant to pay the claimant, in total, a large sum of money. Then, after the hearing, the magistrate, outside their own judicial function, in their private capacity, most likely showing favour to the claimant, i.e. the counsel, steps down from his seat, walks round to the claimant's desk, and then signs the paperwork, which is a bit odd. Now, bear in mind, we're talking about Form B. This is the form in which there are multiple people on the list. This takes place in a room that is hired by the council from the court, and huge numbers of people are on the list, and somehow the judge is bringing his judicial mind to each and every one of those people in as few seconds as it takes to make the pronouncement that there is a liability order. And it's a pronouncement which is spoken. It's not written down. And if you're not in the room, how could you possibly hear such a pronouncement has taken place? The reporting of that, which is what the council then do, is hearsay, which is not evidence. And that's why they can only generate a notice. So why would the magistrate, the justice of the peace, why would they sign this piece of paper that's generated by the council, this notification? Is it sheer ignorance? Or maybe they're being paid? Or is it a favour that's rewarded? Perhaps, a little bit of the old cash in hand, nobody need know, a wink is as good as a blind bat, that kind of thing. That act, the act of signing on the paper of the claimant, shows favour. And now favour means bias. And bias would mean voiding the order that the magistrate has now pronounced, because that would not be justice seen to be done. And yet, that document will destroy lives. That document that has just been signed by the Justice of the Peace and dreamt up by the claimant has now got the power, it would seem, although it doesn't have any authority whatsoever, but it is taken to mean that they can destroy lives by coming round with threats and menaces and take people's possessions, demanding money, as we will see. The ongoing practice of the justice signing what is now the claimant's paperwork carries significant legal and moral implications, clearly. So, another freedom of information question was asked. What duty or function of the court is the Justice of the Peace performing by signing the council's generated council tax notice of liability order? And the answer came back from L. Brooks, Operations Directorate of HMCTS, His Majesty's Courts and Tribunal Services, saying, if a Justice of the Peace were to sign a liability order, they would not be exercising a judicial function, because it's not a court document. Now, remember the MOJ, the Ministry of Justice Directive that we spoke about at the beginning of 2003, and Sion E. Jones said legal advisors were reminded of it in March 2023, which was just a year or so ago. So, the Justice Clerk Society back then issued a paper titled Procedures of Liability Order Applications. Now, it's quite a complex document. I've shown it on the show before. But under the heading of orders, and I've read this out on the show before, it states the following. Just to remind you, let's have a look. The order is made when the presiding justice pronounces it, and it is recorded in the court register. Since repeal of the prescribed order, so they are admitting again that it has been repealed, there has been no court-produced order. No court-produced order. It's there in black and white. The council's software should generate a notice that the court order has been made, which is sent to the defendant. This should not be signed or endorsed with the name of a JP, Justice of the Peace, or a court officer, and then in brackets it says, still less, a justice's clerk, ! Which sort of it gives the impression that this is what's been going on. But the booklet goes on to say, some councils are still sending out their notification in the form of a liability order. But even so, it is not a court-generated document. It is notification of the order made by the justice. And that notification, of course, is just simply hearsay. So they, the courts and the councils, well, they obviously know it's a directive, and they know that the directive is not being followed for 2 decades, 20 years. And the Ministry of Justice, the MOJ, admits, as we saw earlier, that they have no idea whether that's being implemented or not. Now, bear in mind that vulnerable families have been thrown out of their homes, had their treasured possessions seized by bully boy thugs, their cars impounded and possibly crushed without a genuine court order. In other words, with no authority from the court. None. Think about that for a minute. How many people have suffered? I mean, this situation is far, far bigger than, say, that recent sub-postmasters scandal that we've seen in the press recently, and yet it still goes on, causing absolute misery. So who's responsible? Well, the directive is clear. I mean, it couldn't be clearer. The council hold a notification, not a liability order. It should not be marked liability order because it's a notification. It should not be signed by the Justice of the Peace. They've been told not to do it. And it does not carry the authority of the court. Remember Sion E. Jones? Her name keeps springing up in this, doesn't it? And she stated in her Freedom of Information answer that since that time, HMCTS and its precursor organisations have employed thousands of legal advisors. So those thousands of legal advisors have been employed for 2 decades. They've actively chosen, seemingly in lockstep, to ignore the government directive. Well, doesn't that beg the following question? Who has instructed them to ignore the directive? Who has instructed the magistrate to sign the notification? Who is instructing these legal advisors to continue to mislead the public with catastrophic implications? And what about the councils? They don't get off scot-free. I mean, they've known about this since 2003, that their paperwork is not a court order. They employ legal advisors in the council who would know this. Ignorance of the law is no excuse. The councils collect the so-called debt by things like attachment to earnings. They take people's benefits away. They instruct solicitors to bankrupt residents. They submit notifications into court, claiming them to be court orders. And then, of course, these same councils instruct enforcement agencies to harass and threaten, often with menaces, usually the poorest and most vulnerable people in the community, until they either hand over their money or seize their vehicles. This has to stop. There is counterfeit, fraudulent practices and falsifying of court documents at the heart of this massive 20-year scandal. Council tax is a scam. So there you have it, the damning evidence that the council tax is a scam. It ought to be unenforceable, and yet we've seen them continue to do this. I would very much like to hear your thoughts and whether you think that this should stop now. I don't mind paying a bit towards the community. I don't mind paying for my bins and a little bit of street lighting. I don't mind paying for the potholes, although I think that comes under a different jurisdiction in the roads. But I certainly don't want to be paying my money to fraudulent outfit. And of course, there is the Aiding and Abetting Act, that if fraud is being taken place, then I should not, legally, I cannot pay this council tax if it is being fraudulently collected, which I and the colleague who's come to put this little presentation together firmly believe that it has. Thank you so much for watching.